So welcome to the American Bar Association webinar, Do We Treat America's Wartime Detainees Better Than Migrant Children? My name is Angie Abdelkader, and I'll be acting as the program's moderator. Today's webinar is hosted by the section of Civil Rights and Social Justice, and it's sponsored by the Rights of Immigrants Committee. It's part of a 6-part national lecture series with a new program on the third Wednesday of every month. We're excited to have a number of other important co-sponsors, including the ABA Commission on Immigration, the ABA Criminal Justice Section, the ABA Center for Public Interest Law, the ABA Section of International Law, and the ABA Government and Public Section Lawyers Division. We appreciate all of your support. It's also important to highlight that none of this would be possible without the technical and logistical support of the ABA staff. Thank you to Paula Shapiro and Allie Kilsgard, as always, for your tireless efforts to make these programs a success. We have a fantastic lineup of speakers slated for this event, so let's jump right in. First is Professor Ryan Vogel, whose article by the same name of this webinar, published in Just Security, an online publication run out of NYU School of Law, inspired this particular event, is with us today. Vogel is an assistant professor and founding director of the Center for National Security Studies and a National Security Studies academic program at Utah Valley University. Previously, Professor Vogel served at the Pentagon as a senior policy advisor in the Office of the Secretary of Defense. He began his career at the Pentagon through the Presidential Management Fellowship Program and was awarded the Medal for Exceptional Civilian Service in 2014. Professor Vogel has also served at the Public International Law and Policy Group, both at the U.S. Senate and the State Department. He's taught law and national security courses at American University in Washington, D.C., BYU Law School, as well as the Chicago-Kent College of Law. Professor Vogel holds an LLM in Public International Law with a certificate in National Security Law from Georgetown University Law Center. He earned his JD and an MA in International Affairs from American University. Professor Vogel is an alum of Utah Valley University, where he graduated with a BS in Integrated Studies. He regularly publishes papers and makes presentations on national security matters and was awarded Faculty of the Year Award at the 2017 Wolverine Achievement Awards. He's a member of the Maryland State Bar, and he served as an honorary colonel with the Utah National Guard. Welcome, Ryan.
Thank you. Okay. Well, thank you. Thanks for inviting me to this. This was a topic that last summer, Ryan Goodman from Just Security brought to my attention and indicated that they were interested in having some kind of comparison to the way that we conduct our detention operations in wartime with some of the things that we were seeing on the news related to migrant detention. And so I agreed to do that. I thought that that was a worthy comparison, and so that's kind of the genesis of some of this discussion today. Before I wrote this article, there were others that had started to make that comparison, and I thought that they were right, that we were treating our wartime prisoners better than our detainees that, or better than our migrant children that we were detaining and others that we were detaining on the southern border. And as I was looking at these things, my background is in detention. So at the Pentagon, it was noted in the bio that I worked at the Pentagon in the Office of the Secretary of Defense. My primary issue set was wartime detention. So I have spent quite a bit of time working on Guantanamo issues and detention issues across Afghanistan and Iraq in the Obama administration. And as some of the issues were kind of coming out in the media, some of them seemed very familiar. In fact, we learned a lot of lessons, I think, over the years of conducting detention operations. At the beginning, I think there was a big influx of detainees, and there was confusion as to what kinds of laws applied, how we should treat them, whether they merited prisoner of war protections and these kinds of things. And so it took some time to develop a real sustainable, transparent, and lawful detainee policy, but I think we got there in United States practice. And now I think in a lot of ways we have a model detention policy for wartime detainees. So as I'm looking at some of the stories that are coming out of these facilities in the southern border and across the United States, it seems like there's some learning that might occur. So my kind of angle on this is in the comparison to wartime detention. Under the law of war, and I should note that at the outset that by comparing detainees, wartime detainees, to migrant children who are detained on the border, in no way am I asserting that the standards from the law of war should apply to the conditions on the southern border. To the contrary, in almost all instances, detainees on the southern border should be treated well above the standard that is required for wartime detainees. But under the law of war, parties to a conflict are required to treat individuals with dignity, humanity, respect. Of course, we're not detaining people during wartime to punish them, unless they're tried in a criminal setting. We're not punishing them by holding them. We're simply removing them from the battlefield so that they can't continue to fight us. Detention is an inherently unpleasant experience. You're being deprived of your freedom if you're being detained, but it is a necessary thing. And as I've argued in other fora before this, it is the humane alternative to killing those people on the battlefield. Even where there's an opportunity to conduct a lethal operation, the responsible governments will try to capture people, and almost always those people are eventually transferred home and able to continue on with their lives. The law of armed conflict provides a whole range of protections and specific protections for detained minors if they come into the custody of a party to a conflict. A lot of the United States detainee policy is found in DoD Directive 2310.01E, and that was last updated in 2017. But for those that are interested in looking at what is the Department of Defense's, what's the US government's policy for detention operations, it's 2310.01E. And in section 3B of that policy, which incorporates the Geneva Conventions and the additional protocols and other parts of international law, there's a baseline standard in section 3B that all detainees be treated humanely, with respect for their dignity, without adverse distinction. And then it defines those things. So what does it mean to be treated humanely and with respect for a person's dignity? Well, part of that is having adequate food, adequate drinking water, shelter, clothing, the basics that you would need for just survival, reasonable access to the open air, educational, intellectual activities, contacts with the outside world. A lot of times that takes place in the form of letters home. ICRC, the International Committee of the Red Cross, will often facilitate those kind of connections so that people are not, their lives are not disrupted to a point where they're not allowed to interact with their family. Additionally, safeguards to protect health and hygiene, protection against the rigors of the climate and the dangers of military activities, appropriate medical care and attention as required by the detainee's condition. And that also includes the detainee's age, and whether it be the really young age groups or the really old age groups. Free exercise of religion, consistent with the requirements of detention, reasonable access to qualified interpreters or translators, particularly if they speak a foreign language, having someone that can communicate with them effectively. So all those are elements of humane treatment and dignified treatment under the law of armed conflict. In section 3D of that same policy, it requires that DoD register detainees, that their property be inventoried, that there be records of their detention, and that their property be maintained. So all along, the understanding is that if you come into U.S. custody, that you're not lost in the system, that you are that you have a number assigned to you, that number is conveyed to an outside party, the ICRC, and that you're not lost in the system. In section 3I, there's a requirement for periodic review. This is a little unique to wartime detention, but the idea that you're getting a regular review of whether you can be detained, whether there's lawful authority to detain you, and whether you should be detained, whether you still present a threat such that it's required that you be held in detention. There's a requirement in 3K that you be segregated from other detainees for a wide range of reasons. And some of that is in age, that if you are a minor, you're separated from the adults, that if you're a woman, you're separated from the men, in order to protect detainees from the kinds of things that can happen in some of these detention camps. In sections 3N and 3O, there are training requirements and reporting obligations. So if a person is going to be involved in watching prisoners of war or detainees, they be trained beforehand. And then once they are doing it, they're required to report any abnormalities or any violations of the law of war, or other policies and directives that would apply there. Importantly, this applies to everybody. So if you're a hardened terrorist, or if you're a child that just happens to be in the same safe house as the people that you're trying to detain, you treat all these people with that same level of dignity and respect. My experience, though, is that in U.S. detention operations, we've gone out of our way to surpass those requirements. So detainees at Guantanamo, for example, were provided with halal food. They're provided with games and movies, reading materials, classes, including painting classes and educational classes for mental stimulation, religious material, educational space, there's soccer facilities and things like that, access to medical personnel, cultural advisors, and a wide range of other benefits and activities. So detainees are permitted to meet with their lawyers, ICRC personnel, their own government representatives, and to correspond with their families. Again, the key here is that detention is not going to be pleasant, but sometimes it's necessary. And similarly, the temporary detention, and some of the other people on the panel today will talk more about the situation on the southern border. They're more expert on that, but it may be necessary to temporarily detain migrants, might even be the humane alternative to immediately returning them to their country where their safety is in question. But if we do it, just like we do with detention operations in wartime, we have to do it the right way. From what we've heard, and this is based on public reporting, there's a lack of hygienic materials, there's a lack of clean clothes, a lack of access to open air, appropriate medical attention, even in some cases, adequate food and water or safe kind of conditions in the facilities. Conditions for sleeping, sufficient protection from the elements. A lot of them, and this is extremely disturbing, a lot of these, or too many of them, have gone unaccounted for or been lost in the system. And that is something that would not happen in wartime detention. We would inventory them from the minute they came into U.S. custody. Which goes to show if we can effectively register and account for detainees on a foreign battlefield in a place where security is not certain, where conditions are extremely difficult, surely we can do that during peacetime in our own territory where we have much more resources and much more of a safe environment to work in. I think part of the problem with what we've seen, and this is again something that should be familiar to those that have worked on wartime detention issues, is that a lot of times we went into these kinds of settings without an intention of having a long-term capacity. So facilities were not designed to hold as many individuals for as long as we held them, and that created some problems. There are some political issues there. Obviously, this kind of gets roped into the bigger immigration issue question, but regardless of what your position is related to the bigger questions, or even regardless of what your position is with regard to the families that are coming across the border, the United States can and should do better than what we've been doing with regard to with migrant children. Again, I'm not advocating that a wartime standard should be applied to children. I think it's actually the opposite. We should surpass what we do with wartime detainees. If we can treat Al-Qaeda terrorists better than we treat migrants on the border, children, then that's not a legal issue, that's a moral issue. We should be able to surpass those requirements. with our detention operations in wartime, we knew going in that if we met the standards and even surpassed the standards that are required by the law, they would not be reciprocated, that Al-Qaeda was not going to hold our people, or the Taliban were not going to hold our people with the same level of respect for the law as we would. We did it anyway. We would go above and beyond the conventions, hold ourselves to a higher standard. And I think that's, in a lot of ways, the kind of thrust of the article that I wrote for Just Security was exactly that. We've done this with wartime detention. We've learned the hard lessons of not doing detention the right way. We've learned those. We've incorporated those things into our practice now. It's time we did that and more for our detention of migrant children on the southern border. So I'll end there for now and look forward to questions and answers.
Great. So thank you so much, Ryan. Next is Lee Gallant. Lee is a lawyer at the National Office of American Civil Liberties Union in New York and currently holds the position of Deputy Director of the ACLU's Immigrant Rights Project. He's also the director of the project's Access to Courts program. Significantly, he is an adjunct professor at Columbia Law School. During the past 18 months, he's argued several groundbreaking challenges to Trump administration policies. He's currently litigating Miss L versus ICE, a case involving the administration's unprecedented practice of separating immigrant families at the border. In fact, in June 2018, a federal court in San Diego issued a nationwide injunction holding the practice unconstitutional and requiring the administration to reunite approximately 2,600 separated families. He's also successfully argued Rodriguez versus Sports, involving the fatal cross-border shooting of a Mexican teenager in Mexico by a U.S. Border Patrol officer firing from U.S. soil through the border fence in Arizona. The Court of Appeals ruling in August of 2018 in favor of the boy's family was the first ever federal court decision to hold the Fourth Amendment applies extraterritorially. Over his career, he's argued dozens of other notable civil rights cases at all levels of the federal court system, including the U.S. Supreme Court, where he was just recently engaged in oral arguments, as well as the Court of Appeals for the 1st, 2nd, 3rd, 4th, 5th, 6th, 8th, 9th, and 11th circuits. He's also testified as an expert before the United States Senate. He's received numerous honors for his work over the years, and last year was recognized by Law Dragon as one of the 500 leading lawyers in the country in any field. In addition, he's a frequent guest speaker around the country and regularly appears in the national and international media. In July 2018, for example, his work was featured prominently in the New York Times Magazine cover story about the ACLU. Notably, he earned his JD from Columbia Law School in 1988, where he was a notes and comments editor of the Columbia Law Review. Welcome, Lee.
So much for having me. So I want to just give people a sort of overview of the family separation policy and litigation, and maybe then, time permitting, touch on a few other things we're seeing with respect to migrant children at the border. So I think most people know that the Trump administration had a family separation practice. I'm not sure that everyone knows the extent of it. And in fact, the GAO issued a report just in the last 24 hours indicating that things are maybe even worse than we knew. I thought I would just give a sort of timeline overview of what we saw and where things are now. I said what I want to do is also, in telling the story, make clear the point that we just heard about keeping track of detainees and how wartime detainees are tracked and how that contrasts with what we saw with migrant children. But I want to stress the more fundamental point, I think, about even if we had kept track of them, you just can't separate children from their parents in the immigration context or any context without a compelling interest. So what we saw in the fall of 2017, leading up to the holidays, is people on the ground, children are being separated. No one really knew the extent that the administration said we're thinking about it, but we haven't really done anything about it. The truth is that they were separating families, and we ultimately went to court and filed a national class action in March of 2018. And what was revealed at the hearing and then later when the judge issued his ruling in June of 2018 was that there were 2,800 families who were separated, including children 5 months old, 6 months old, numerous toddlers, many under 5 years old. And the judge said, look, you got to reunite all these families. We propose that the children under 5 be reunited within 14 days, a deadline the government missed, and that the rest of the children be reunited within 30 days, another deadline the government missed. And what became clear is not that they had separated thousands of children. Based on what we now know was their view that if we start doing this horrendous act of taking children away, it will deter families from coming. We know that it deter families from coming because people were facing options choice of they could be killed in their own country or they come. And every family that I talked to said, what choice did I have? This is the worst thing that's ever happened to me, having a child taken away from me. But if I had stayed, it could have been even worse. And so the reason the families were not reunited immediately is because the government wasn't set up to reunite the families and, in fact, had not actually tracked all the families. And that became clear. The judge said it seems that the government tracks property generally than they better track these minor children. 2,800 children. What we then learned is that approximately 470 of them, the parents have been deported already without children, and were sitting on places all over the world, primarily without their children. Then took us almost a year to track all those families down and give them the opportunity to reunite with their children. We had hoped that that was the end of it. But at some point during the year, HHS came out with an internal report said many more children had been separated even before zero tolerance. The government refused to give us those names. We had to go back to court. The government said, no, those kids were separated well before the injunction. We shouldn't have to give you the names. The judge said, absolutely not. We are not in this country going to have a situation where potentially thousands of children were taken from their parents. We don't know about them. We don't know where they are. The government then said, we need 2 years to the ACLU the names of the children. And not to give us actual find the children, but 2 years just to give us a list so that we could then go search for the families. The judge asked why they need 2 years just to give us a list. And then the government sort of candidly admitted, the most candid acknowledgement up to that point, that they simply had to track the kids. And we're going to have to recreate files all the children that were separated, and they wanted 2 years to do that. And at this point, the children had already been separated 18 months, 2 years. They were little children, so separated potentially half their life or 3/4 of their life. Their 2 years would have meant that for a 1-year-old separated, they would have been separated 4 years out of their 5 years of existence. The judge said, no, you're going to do it 6 months basis. We finally got that list, and it was another 1,556 children. We're now searching all over the world for those parents because the contact information the government gave us is stale, needless to say. So we have reached some phone contact. Many others we're searching for. That search as the last few days has had to be delayed and postponed because of the virus, and people just can't go into various regions of Central America looking for the parents. What we also learned, though, is that since the injunction, the government continued to separate families, and they have told us about 1,200 they have separated, and the rationale there was, well, Your Honor, we know we can't continue separating based on policy, but we can continue separating if we think the parent presents a danger to the child. And so what we learned, though, about those 1,200, based on the government's own data, was they were separating even for minor crimes that had occurred decades ago. A parent had a nonviolent theft, $500, a conviction for that. They would separate, and they would say, well, we can't detain criminals with children. And so now it's continuing, made far worse than the information we're using, according to the GAO report that was just issued this morning, saying the government has continued to not track families they're separating since the injunction. So this is really, and I think Ryan said this, whatever you may think about macro immigration policy and various asylum policies, I think the one thing that brought the country together and was maybe the only silver lining in all this was that people from both sides of the aisle came out and said, look, whatever we do, we can't take little babies from the children. And I think that's the challenge, is to continue galvanizing people, understanding it's still going on, and to keep that outrage, because I think people are, there's just so much going on, and it's understandable. And now in particular with the virus, is the children, people are sort of out of sight, out of mind. It hit a peak, and then it hasn't got much attention. The other part of it is, of course, that when the children are detained, they're often detained in horrific conditions. And that, that varies. I don't want to say that it's uniform, that the children are always detained in poor conditions, but what we've seen is that a lot are being detained in horrific conditions. So that simply adds to the trauma of what's going on. And even beyond the family separation, the administration is now enacting policies that have traumatic effects on children, life and death consequences potentially, of sending families to Mexico to wait for months and months and months for their hearing. They're living in squalid conditions. It is extremely dangerous. They're being picked off by cartels. They can't, to the extent they have a place to stay, they can't leave because they know that a cartel will immediately rob them or worse. And so we have all these families. Originally, the administration said they weren't going to send families to Mexico to wait for their asylum. This is what's called the MPP policy. But now thousands of children and families are sitting in Mexico waiting for their asylum hearings. So I think all across the board, the administration has really treated terrible cruelty. Time, the long time, the consequences, because what the medical profession has said in our case and continues to say is that this kind of separation will do irreparable damage to children, and that we need to get the medical help as soon as possible. Otherwise, it may very well be, it's too late. So we and other people have brought damage suits to try and get the family some money, but more importantly, get a medical fund established so that we can have doctors come see and deal with the trauma. And it's not just going to be the children, but it's going to be the parents who have been affected by having their children ripped away and spending every night worrying about where their children are. And even when the children ultimately come back, the dynamic between the parent and child is so damaged because the child, understandably, is too young to understand why the parent didn't protect this, blaming the parent for letting them being taken away, and saying, didn't you love me enough to stop them from taking me? Why didn't you stop them? That's producing enormous guilt on the parent. So I think we have a lot of work to do to fix the damage that we've already done, but we have to, going forward, stop doing this to all the migrants, but particularly the children who are most vulnerable. So I'll stop there now, if that's okay.
Yeah, thank you, Lee. That was a very powerful presentation, and we look forward to re-engaging during the Q&A. Speaking of which, just a note for members of our audience, you'll notice that on the bottom of your screen, if you move your mouse, there are various prompts below, including a section titled Q&A. That section sort of on the bottom middle of your screen, that is where you would pose questions for any or all of the panelists. So following the last presentation, which will be shared by Chloe Walker, you'll have an opportunity to engage in a Q&A with the panelists. And so you are invited to input your questions at any time, can be directed to specific panelists or all of them, but that's how you would do so. Just double click on that Q&A button on the bottom of your screen. If you don't see it, you just need to move your mouse for it to appear, and we'll be monitoring your questions accordingly. So again, Lee provided us with a very powerful presentation regarding the status and history of separation of families under this administration. Our next speaker is Alvaro Botero, and a note you may have noticed in the promotional materials that Felipe Gonzalez, who is the UN Special Rapporteur on the Protection of Migrants, was slated to join us. Unfortunately, he's been adversely impacted by the coronavirus, but was kind enough to arrange for Alvaro to join us instead. And he too works with the United Nations, and so we're grateful to have him with us. So Alvaro is a member and rapporteur of the United Nations Committee on the Protection of the Rights of All Migrant Workers and Members of Their Families, as well as a coordinator of the OAS unit on refugees and forced displacement of the Secretariat for Access to Rights and Equity of the Organization of American States. He's also a coordinator of the Technical Secretariat of the Comprehensive Regional Protection and Solutions Framework. Previously, he worked as coordinator of the section of monitoring of human rights and rapporteurship on the rights of migrants of the Inter-American Commission on Human Rights. Significantly, Alvaro is also an adjunct professor at the Washington College of Law at American University in DC, where he is based. He teaches classes to law students on refugee law, as well as international migration law. So thank you for joining us, Alvaro.
Okay. Thank you, Angie, and it's a pleasure to be part of this webinar. As Angie mentioned, I'll address the issues at the stakes from an international perspective, and I'll try to give an overview of the work that human rights bodies and special procedures has done in relation to migrant children in the U.S. First, I should stress that for international and regional human rights mechanisms at the UN, United Nations human rights system, and the Inter-American human rights system, the biggest challenge is that the US has not ratified most of the UN and Inter-American human rights conventions, which kind of place the US out of the scope in terms of the monitoring of these bodies, especially treaty bodies. Nonetheless, there are other mechanisms like the special procedures, such as working groups and special rapporteurs, like the one that was mentioned by Angie, Mr. Felipe Gonzalez, the special rapporteur on the rights of migrants at the UN, that can also monitor situations related to the rights of migrants in all the member states of the UN. At the Inter-American level, the fact that the US hasn't ratified the American Convention on Human Rights means that it is only the Inter-American Commission, the one that has sort of jurisdiction in order to address issues relating to human rights violation under the American Declaration on the Rights of Men. But the counter-argument from the US government is that this is not a binding instrument. Nonetheless, through the years, the Commission, and especially through its rapportership on the rights of migrants, has been able to monitor to some extent several situations related to the human rights of migrants, asylum seekers, and refugees in the US. And in that sense, for example, to conduct on-site monitoring to the southern border and other places in the US, like in 2009, 2014, and last year, the Commission conducted another visit to the southern border to monitor the several situations that are having an impact to human rights obligations in the US. So I will refer to some of the measures that have been taken by the US government in relation to migrant children in recent years. And of course, I will also address the impact of the zero tolerance policy. In that regard, several human rights mechanisms at the UN human rights system and also at the Inter-American human rights system, such as the UN Special Rapporteur on torture and other inhuman, cruel, and degrading treatment, have stressed that the detention of children and the separation of families has no justification applicable in migration context, taking into account that making these detentions suppress the best interest of the child, which is like the most important consideration to take into account in any situation that you are dealing with children, and also the right to development. However, the position of the US is that, well, they have not ratified the Convention on the Rights of the Child, and it has, but it has signed this treaty, and therefore it must refrain from acts that defeat its object and purpose. Further, the UN Human Rights Committee has interpreted the International Covenant on Civil and Political Rights, which the United States has ratified, to require states to take into account the principle of the best interest of the child. And in this connection, and relating to this issue, also the Special Rapporteur on the Human Rights of Migrants expressed concern at the mass detentions of persons entering to the US territory and the automatic separation of families. Firstly, the violations to which entire families are subject when they are separated, the arbitrary detention of children and other conditions to which they are subject were pointed out by the Special Rapporteur, which also coincide with many of the issues that were pointed out by Ryan and Lee. The United Nations mechanisms, such as the Special Rapporteurs that I just mentioned, have called the US for the release of migrant children from detention and to stop using the detention in order to deter the irregular migration. The UN mechanisms has also understood that the family separation and detentions were taking place without prior notice or the regular and legal conditions required by international instruments and conventions in order to guarantee and protect human rights. Likewise, the UN mechanisms has considered that the trauma to which children are exposed without end, from the moment of the separation to the amount of time they remain in detention center. The Special Rapporteur on Migrants also noted that the children should be treated as children and not exposed to conditions of repeated violations, as is the case with the implementation of the zero tolerance policy. Another thing that I should mention from the international perspective is that, considering that irregular migration, for example, the fact of the irregular entry of a person into the territory of a state, or when the person enters to a territory and remain more of the time that the person was authorized in the first moment, it just accounts as an administrative offense. So in that sense, the standards that has been developed by the Special Rapporteur on Migrant, but also by other special procedures and by the inter-American bodies like the Inter-American Commission and the Inter-American Court, is that immigration detention should be an exceptional measure and should be applied as a last ratio measure, as a last resource measure. And in the case of children, authorities always have to take into account the best interest of the child. The standard is even higher. It is not just the exceptionality of the detention, but it's the non-detention of children, because it can never be understood that the detention for an administrative offense, it might be in the best interest of the child, and also considering all the impacts that the detention might have in terms of the right to freedom, but also in terms of personal integrity and etc. Also, in relation to the issues of family separation, one of the few mechanisms that international bodies has in order to address with issues relating to migrants in the US relates to precautionary measures that can be granted by the Inter-American Commission on Human Rights. In June 2018, a couple of months after the beginning of the implementation of the zero tolerance policy, the Inter-American Commission received a couple of precautionary measures in view of the situation of thousands of families that were being separated in the United States because of the zero tolerance policy. In that moment, well, after a couple of months and exchanges with the government requesting for information about how it was implementing this measure and the impact that this was having in families and children that were separated from their parents, the Inter-American Commission determined that the right to family unity, the right to integrity and identity of the children were at risk as a consequence of these policies, and requested the government to take the necessary measures in order to guarantee the above mentioned rights. Some of the measures that the Commission recommended to the US government were the following. In line with these precautionary measures, the government should take all the necessary measures for the family reunification of children with their biological parents. The government should also take the necessary measures so that while the process of family reunification was taking place, communication between parents and children was immediately guaranteed in order to safeguard the best interests of the child. Also, in order to determine the situation of the violation of the rights of the child to family unity, the government should provide medical, psychological, and consular services. And in the event that the parents were in another country, as it was the case of many parents that were deported before their reunification, the government should seek international cooperation to ensure their reunification and suspend all migration procedures involving the separation of children and their families. Unfortunately, in this regard, the position of the US government was basically to emphasize that it was, as a country, its duty to regulate the migration-related issues, and that it has the discretionality to decide the policies relating to migration. And it also noted that it was making great efforts to mitigate the factors that trigger migration from Central America. Another of the bodies that have within the scope of their mandate to try to address to some extent the impacts of the zero tolerance policy has been the UN Working Group on Arbitrary Detention, and several other special rapporteurs within the UN. And in that sense, there has been many press statements, which is basically what these bodies can do unless they are allowed to visit the country, addressing the violations that policies of the zero tolerance policies are causing to basic human rights, like the right to personal integrity, the best interest of the child, and even in the case of the special rapporteur on torture, has pointed out that in some cases, the separation of children from their family might account to an inhuman degrading treatment. Among the requests that has been done by special procedures at the UN, the special procedure has requested to the US government to provide information concerning the conditions of detention of the children and the exact figures of how many children has been separated from their families. But well, as you might be aware, that's a figure that we might not be able to know, considering the investigation that has been developed by internal mechanisms at the US. Also, something that is important to mention within the limits of the mechanisms available for international bodies and regional bodies is that after a year of negotiations with the US government, the Inter-American Commission was able to conduct an on-site visit to the southern border in August 2019. And during this visit, even which was during a very limited time, the Commission was able to monitor conditions of detention, asylum procedures, and conditions of reception at the border. During the visit, some of the recommendations made by the Commission were that the government should prioritize the best interests of the child in all administrative and judicial decisions regarding the situation of children and adolescents and their families. The government should also prioritize the principle of family unity and disregard the zero tolerance policy and policies and practices that criminalize migrants and their families under any circumstances. And continue to implement actions aimed at the reunification of families that has been separated. And to this end, the state must promote the exchange of information among governments and agencies that make it possible to locate children, adolescents, and their relatives. But in conclusion, what we have been, from the international body's perspective, able to see with the actions that has been taken by the US government in relation to migrants and asylum seekers is that it is very clear that it's not a correlation, that there is not compliance in terms to international norms and international standards that has developed at the UN level and also at the Inter-American system. A major challenge in order to determine the extent of this violation is the lack of access to monitor these situations in the US. For example, in the case of the UN Special Rapporteur on Migrants, I know that since a couple of years, he has been requested the authorization of the US government to conduct an on-site visit to the US in order to monitor all these situations, but it hasn't have the authorization of the US government. And this is also the situation of many other UN bodies and also some of the challenges that has been faced by the Inter-American Commission on Human Rights. Something that, considering the challenges that international bodies have in order to have an impact with the US government, that we have seen as unusual practice at the Inter-American Commission, which is the place where I worked before, is that even when the government might say that these are not binding mechanisms or that these are not binding obligations, when you see the interaction between the decisions of these international bodies and an effective strategy in terms of advocacy and media, this decision might have an impact, and that has been proven in cases of precautionary measures granted to prevent the deportation of some Central Americans to their countries like El Salvador. But we are also very aware that not all the organizations have the capacities to have like huge advocacy campaigns in order to promote and to give visibility to the decisions and the work that is conducted by international and regional bodies. I think I'll leave it here for now, and I'll be happy to address your questions and comments at the end.
Wonderful. Thank you so much, Alvaro, for that engaging presentation. We look forward to speaking to you during the Q&A. Next is Chloe Walker. Welcome, Chloe. She is a staff attorney with the ABA's Children's Immigration Law Academy. She brings her training as a macro social worker and lawyer, along with her prior practice in both family law at Gray, Reed, and McGraw and immigration law at the Tahrir Justice Center to her work at the ABA. Her career in child advocacy began as an AmeriCorps volunteer in Austin, Texas, where she spent 2 years with Literacy First, working with Spanish-speaking first graders who were behind in their reading. Chloe earned her JD and Master's in Social Work from the University of Houston in 2012. At UH, she served as an editor for the Houston Law Review and worked for the Center for Children, Law, and Policy. Internships with the Texas Legislature, the Department of Family and Protective and the Texas Civil Rights Project provided her with an intersectional lens through which to advocate for the rights of children and adolescents. Chloe is a New Leaders Council Fellow and honored in 2019 as one of the 50 outstanding alumni of UH Graduate College of Social Work, where she also taught social policy analysis to first-year social work students. She previously served on the boards of directors of the Texas chapter of the National Association of Social Workers, as well as Equal Justice Works. So thank you for joining us, Chloe.
Thank you so much. And I've got a PowerPoint. I'm a visual person and I'm gonna walk through some stuff on our website as I do this presentation. So let me pull that up. Okay, so hopefully you can see my slides up on the screen now. I just want to say thank you so much to NG and thank you to all the other speakers for shining light on some of these issues which can feel quite devastating that in regards to our reception of immigrant children on the border. And the real impact that it has, on them personally, on their families, and also on their legal cases. So before I start my section of the presentation, I just wanted to create a little bit of space for all of us on the call to just kind of absorb the information that we're hearing. It's a lot, and acknowledge any feelings, that it evokes for us. And I've included this quote, the expectation that we can be immersed in suffering and loss daily and not be touched by it is as unrealistic as expecting to be able to walk without getting wet. And I think because these challenging times and we're progressing very quickly to lots of changes, it's we don't always have space to stop and think. So I'm just going to create a little space for that right now, if that's okay with everybody. And for me, I definitely have feelings of sadness. I have feelings of frustration about everything that's going on. The updates on the family separation lawsuit, hearing about sort of our lack of ability to comply with international standards. And I also, I do feel hopeful about the direction that we could be going. And I think what gives me hope is the work that we do at CELA and getting to work with a lot of the attorneys and pro bono attorneys that are on the ground doing the work. So the purpose of me kind of chiming in here is to really talk about opportunities to engage and to engage in support of children who are facing deportation around the United States. And I think the good news is that there are ways to support children in your community, not just on the border. As they progress through the border facilities, potentially through ORR detention or family detention, and are hopefully released into the community while their immigration court proceedings are happening. You can see on this map that there's immigration courts all over the United States. So that hopefully includes communities of those on the call. There are some big gaps out there that you'll see, but that doesn't mean that there aren't children living in those communities. They will have to report to their closest immigration court. So even if you don't see your city on this map, there are likely organizations in your area and children who are for support. So I did just want to highlight that unfortunately, children in immigration proceedings are not entitled to free appointed legal counsel or best interest advocates like those of us who may have worked in the juvenile or the child welfare systems. may recognize as kind of the best interest standard that Alvaro was mentioning for children who are in court proceedings. Oops, I think I'm on an automatic timer. And in fact, about 35% of children facing deportation in the United States are doing so without an attorney. And that's despite a huge network of nonprofit attorneys that are both doing this work directly with children as well as working with pro bono attorneys to do the work. And I've put a bunch of logos on this slide to kind of, you might see one from your community. This is not a comprehensive list, but there are a lot of folks out there doing this work, and it's still not enough. And even in places like Houston, Dallas, and Charlotte, which are big cities with lots of organizations and attorneys doing the work, they still have the highest number of unrepresented juveniles in the court system. And the numbers are huge. There's large numbers of children that are coming to settle in our communities. And so that brings me to the Children's Immigration Law Academy, which is where I work. We are one of the 3 offsite projects of the ABA Commission on Immigration. The other 2 projects are ProBar and IJP, who work directly with, they both work directly with detained adults in San Diego and Harlingen, Texas on the border. And ProBar works with detained children as well. But CELA, we're an expert legal resource center. We were created by the ABA about 4.5 years ago. And our mission is to empower Texas UC champions, who we see as advocates who guide children through complex legal procedures, to do so with courage, competency, compassion, and creativity. And we build that capacity through trainings, through providing technical assistance, and facilitating collaboration. Across the opportunities that are available to anyone across the United States are our webinar trainings, our in-person trainings in Houston, and our Pro Bono Matters for Children Facing Deportation platform, which is what I'm gonna talk specifically about here in just a second. And we also do support folks who are working in those emergency reception centers like Tornillo and Homestead and Fort Bliss, none of which are currently housing kids at the moment, but when that happens, we support. And specifically in Texas, we provide individualized technical assistance. We provide collaboration among the folks that are doing the work, and we have some Texas-specific training and resources. We're a small, but we have a pretty diverse knowledge base and background in this work. And what I really want to talk about is Pro Bono Matters for Children Facing Deportation. And this is our platform funded by the Vera Institute of Justice that is a vehicle for the nonprofits, the legal service providers who work with youth. They work with the youth who are detained in or are or released into the communities, as I mentioned before, to identify ways in which pro bono attorneys can support the youth. So then there's this one common space where interested lawyers and advocates can search and share the available pro bono case opportunities to make a match between the need and the will to help. And there are lots of different kinds of opportunities shared on the platform. The needs of the particular youth may vary depending, where in the country they're located, if they're already working with a nonprofit, or if they're in one of those areas of the country where there's not a nonprofit. And I say that because, there might be resources available through the nonprofit to support you through the work as you do it. But in the event that there's not, I'm also going to talk about some resources that CELA has available. And this is the link, and you're welcome to go to it now or click on it, but I'm going to walk through some screenshots of our website to give you a picture of how to do this. So here, when you go to that hyperlink, you'll see our portal, which is here. And then you can, if you scroll down, you'll see a catalog of pro bono opportunities. So you can imagine that the opportunities change daily as the needs of the children facing deportation and the nonprofits who work with them change. But these are 2 examples I pulled off yesterday. One is here in Houston, where I'm based, Harris County, and the other is in Miami from Broward County. I think at the moment we have opportunities in 10 or 11, 12 different states. The portal is designed by SavvySuit, and it's designed to be really easy to navigate, to easily connect with a nonprofit or share an opportunity with a colleague. So for that reason, there's no login required. You can literally look at these opportunities right on our website. And so you'll also kind of just see a really brief description. Click on interested right there on the card. Then you just need to fill in your name, email address, phone number, and bar number, and that'll connect you directly to the nonprofit that's posted the case. And the bar number is optional here, but it's really, really helpful to the nonprofits on the other end. If you include your bar line as a baseline to indicate you're an attorney, and there's also a comment section, and it's always really helpful to kind of get a little bit of information about where you're coming from or what your interest is or your background. And then if you're, don't have the capacity to work opportunity, or if you don't see one in your area, you can also share an opportunity with a colleague that might be in another field or in another geographic region. So you can just click on that share button in the middle of the card, and you'll get a link to share the opportunity. And I've just put together a quick email you could send to your colleague with the link, sharing it as an example. And whether or not you're working on a pro bono opportunity, or you just want to learn more information about children facing deportation, we have you covered. We have a lot of resources on our website that really focus on, the legal substantive relief that many of the children are eligible for, as well as kind of how immigration court works. It's a whole different ballgame than some of the other courts that you may have been in. We're really here to help make the process a little more tangible for folks who are willing to step up and give their time to meet this need. So you'll see on that portal, we've got some resources linked to the side there. One I just really want to highlight, it's a good place to start, is a series of webinars that cover several different basic topics, like introduction to working with unaccompanied children, introduction to removal proceedings, which is immigration court, what is asylum, what is special immigrant juvenile status, things like that. And we're also working on a comprehensive written pro bono guide, which will be kind of like the written complement to these webinars. If you information that way, and that should be coming out in the coming month. And last, if you just want to stay in the loop about opportunities or stay in the loop about resources as they come out, you can click on this link, which is also on our web portal. It's also on the handout that you should be getting with the presentation, and you'll just get an occasional email from us highlighting opportunities or different resources that we have available that might be helpful. So that's it, and I just, again, thanks for your time and interest in this and letting us speak about it.
Thank you so much, Chloe. So often we're confronted with news that's so jarring, or we attend events such as this where we're, we feel a little bit overwhelmed with so much negative information that we're not quite sure what to do afterwards. So the fact that you're actually providing each of us with an opportunity to serve migrant children in a pro bono capacity is really important. So thank you for devoting your time and allowing us that chance. So at this time, we are going to remind the audience, all of you, that you do have an opportunity to pose questions using the prompt on the bottom of your screen that's titled Q&A. You'd simply type your question, and we'll be monitoring those questions and posing them to the panelists as appropriate. So we're going to begin our Q&A session. And so Ryan, I'd like to re-engage with you. You provided us with this comparative analysis of certain requirements that need to be met by the U.S. government with respect to wartime detainees, in contrast to the treatment that many of these children have endured in immigration detention centers. And again, it's sort of a jarring reality that I think many of us are aware of, but I think that comparative perspective is a valuable one. I was wondering, in light of the information that has emerged since you initially wrote that particular article, what specific recommendations do you have for the administration? I know that there have been some changes. I know that we also heard from Lee, who's indicated that according to the most recent information from a government watchdog, separation continues to occur and the children are not being tracked as they should be. So what specific recommendations do you have?
So I think maybe 3 recommendations up front. One is to just immediately start to inventory and categorize people that are coming in. There's no reason in the world that we can't keep track of people that we're controlling, right? That we're capturing and holding. So that would be the first one. The second one is to start to permanentize some of these facilities, or at least address longer term issues related to their operation. So even if the administration doesn't think they're going to be doing this for the foreseeable future, to have facilities that are designed for this purpose, to hold a wide range of age groups and people with different needs and that kind of thing. If we're going to be holding people, again, we need the right facilities to do that. And then I guess the third one is, one of the great things about wartime detention is that you do have that neutral third party that's able to come in, assess conditions, give recommendations, and that kind of thing. That's the International Committee of the Red Cross in the wartime context. If there is a neutral, objective third party that can be allowed into these facilities to, again, do those same kinds of things, allow for communications, keep track of people, so help the government to keep track of people, give recommendations on ways that they could improve the operation and ways that they could better comply with both domestic and international law. I think that kind of group would be extremely valuable and would improve the process tremendously.
Wonderful. Thank you so much. Lee, I'd like to turn to you. And I know that we have a question from the audience, and I have a few of my own. And specifically, the audience member thanks you for all your efforts, Lee, you and your colleagues at the ACLU. And the question that's posed is, what is the situation now? I know that you provided us with a timeline and sort of a historical perspective of what has occurred and what's transpired with respect to the litigation. The question from the audience member is, what is the situation now? And I also have a few questions of my own, but I'll allow you to respond to that one first.
Yeah, sure. Thank you. So we're focusing in a few areas right now. One is to find with our partners who have been incredible. I mean, there's lots of them, but there's a sort of formal steering committee headed by the law firm Paul Weiss, and Kids in Need of Defense is on it, Justice in Motion that operates on the ground in Central America, and the Women's Refugee Commission. That is the first thing. Is we are still looking for the families, the pre-zero tolerance families. So that is an absolute priority, and we are spending an enormous amount of time trying to track them because, as I said before, the information we have, the contact information is stale. So there's been literally a lot of door-to-door in Central America looking for them. And, the judge is asking for a timeline, and what we have said to him is, look, we're just going to continue until we are absolutely certain we've found everyone. I have no idea how long that's going to be. The second thing we're focusing on is making sure the tracking by the government and then the sharing of information about a separate family situation goes to people on the ground, the nonprofits on the ground, and legal service providers, so that we can try and reunite the parent and child. So that's a very part of it, both for the future, if there are going to be separations, which we hope, that reduce to the way it was done under the Obama administration, which is only if there was a genuine objective reason to think the parent was a danger to the child. That kind of tracking and reuniting parents and children who shouldn't have been separated. The third part, as I mentioned, is this effort, damages suits and other efforts to get trauma relief to the families. That is in the form of physicians, social workers, and also to get them some compensation. I think we're looking at sort of that as a long-term thing, but it will depend a little bit potentially on the change in administrations. So those are the sort of three main things we're focusing on. Unfortunately, the judge has allowed them to separate even for minor crimes, and so we are continuing to think about ways to try and stop them from separating based on minor crimes. But in the meantime, we need the information tracking so that we can try and reunite if the separation didn't even fit the government's own criteria. So that's sort of a rough overview of where we are now.
Thanks, Lee. Just a follow-up question. I know that you had discussed, and the polling data shows that there generally is bipartisan opposition to zero tolerance as a policy, this idea of separating children from their family members in order to deter parents from migrating to the United States. In light of that, I'm wondering what, if any, kind of legislative proposals or responses we've seen since this policy first emerged to prevent this from occurring in the future.
Yeah, that's a great question. There's been talk about it, but it sort of died down. And so I think it's a complicated question about how to put legislative standards in, but I think you're asking the right question. Is we don't necessarily want to rely on court orders and going to court all the time. And I think ultimately it would be nice to have some legislation. Where that will go, I don't know. And things obviously right now, probably not the time to push it, but I think you're absolutely right to bring that up as something we need to get back to, of figuring out how we can do it. And it will be complicated to figure out where the bipartisan support is. I think there'll be bipartisan support for no more systematic family separations, but how much deference the Republicans are willing to give to DHS to say, well, look, you have your judgment about whether a parent is being abusive, because that's a wide range of discretion. I mean, we've seen cases where they're separated based on a guard saying, well, I don't think the father changed the diapers quick enough. And so we obviously don't want to have that. But on the other hand, the HCA has always said if there's genuine abuse, separate the standard welfare practice. How to codify those standards, it's tricky. State law codifies them as the best interest of the child and very high standard. But whether that'll play out at the border, I don't know. But I think you're asking the right question.
Okay, thank you. Lee, I guess one more question. I know that you had spoken about some of these issues in terms of long-term goals, but in a short term, what efforts, if any, has the government or other relevant stakeholders made to address the trauma that these children have suffered? I know that, this is the psychological trauma has in fact been documented by government blogs themselves. So in terms, this is not an issue or a matter that should wait several years as litigation plays out or as funds are established. Is the government taking appropriate steps to address the trauma that these children, not to mention their parents, have suffered because of the policy?
Yeah, so that's another good question. The short answer is no, the government is not doing anything about it. We are having to litigate that. It's possible that there'll be one suit where the government decides they won't appeal and they will allow the people who brought that lawsuit, public counsel and others in California, to allow the parents to be contacted and get one doctor's visit. But, I think ultimately we need a sort of more systemic solution. And so we are trying through lawsuits, but you said that takes a long time. The other thing we're trying to do is see about organizing pro bono doctors. Maybe we'll get reimbursement for them after. But, that's a big effort. We need to find the parents, get the doctors to them. People are spread out all over the world, or even all the U.S. But I think, you're right that needs to happen as quickly as possible. There's been enormous efforts by the medical community, which has been great. But one of the things we're trying to do is systematize how to doctors to each family.
Good.
With the government's help, because the government is not doing it.
Yeah, I can't help but wonder, even on that score regarding the traumatized children and the psychological services that they require, whether or not legislative responses might be appropriate too, particularly because so many Americans had a visceral response to zero tolerance.
And I think that, yes, I need to interrupt you, sorry.
No, that's okay. I was just saying that, and since obviously this trauma is not a matter of speculation, but has actually been documented by the government itself.
Yeah, that's absolutely right. There have been some talk about legislation. I think we're hoping that some of the lawsuits up in settlements and maybe Congress steps in, because it's not going to take an enormous amount of money to get doctors to see the families, not relative to the harm that was done and how outrageous it was, and other steps the government could take. Thus far, there's been no movement on that. The government administration is not doing anything to provide real help.
Great, thank you, Lee. We're really grateful for your efforts. Alvera, I wanted to turn to you next. You spoke about this issue from an international perspective, and from an international perspective, we know that the United States, enjoys status as a global hegemon, and as such, when it implements and effectuates policies such as zero tolerance and family separation, it not only has an impact within its own borders, but there are ripple effects around the world. In fact, it sets a tone oftentimes in terms of policies that other countries may choose to pursue in this respect. Or do you have concerns that this may set a negative precedent, not only in terms of future administrations within the United States, but just in terms of the global standard with respect to how migrant and migrant children should be treated, and seeing other governments emulate similar policies within their borders?
Well, thank you, Ajit. That's a very hard question to answer. Of course, it's very, the US tend to have such a dominant position internationally that in many cases sets an example for the policies that are implemented in other states. And in some ways, what we are seeing now in the US, it's also related with other policies that are being taken in order to deter migration in other regions of the world, and kind of like strengthening that trend of externalization of border control, which is something that has been promoted at the European level, but also have expressions in recent history in the US. So of course, like policies like this might have a ripple effect in other countries. And what we are seeing from international bodies in relation to the development of the situation in the US with neighboring countries in the region is trying to adopt those measures directed to externalize the border control, not just securitizing the border with Mexico, but also using agreements with Mexico and Central American countries in order to prevent migrants and asylum seekers even to leave their countries. So yeah, in general, what we are seeing, if we analyze the measures that has been taken by the US in recent years, it's like a closure of legal avenues for migrants to reach the US territory through legal avenues, or even to remain in the US, for example, through the measure that has been taken in relation to DACA or to the TPS. But in relation to measures related to separation of families, I think the criticism from international bodies and the excellent work that has been done by civil society organizations and by advocates and litigants in the US, I think in some ways have established a line that those kind of actions are not allowed in a democratic society, like to go to the extent to separating families that haven't even committed a crime. So at least I would hope that is kind of like a protected area, but yeah, it's very difficult to predict nowadays. What we are clearly seeing it's, for example, many of the actions taken by the government trying to push the control of migration to other states in order to deter the possibilities of people to reach US territory, even if they have international protection needs.
Thank you, Alvera. We're glad that you're here with us today. Lastly, Chloe, I wanted to talk to you. You know, we know that in a criminal context that individuals have a right to counsel, but that's clearly not so in immigration proceedings in the United States. And yet it seems outrageous that children would in fact be placed in removal proceedings without the benefit of counsel. And in response, we've seen in the last decade the emergence of certain legal aid organizations such as Kids in Need of Defense to help fill this void. Again, I guess similar question to you. Are there any policy initiatives or legislative movements to address this void, to ensure that immigrant children who are placed in removal proceedings do have the benefit of counsel given their lack of capacity and inability to actually represent themselves effectively before an immigration judge, and in proceedings where an attorney from the Department of Homeland Security is actually prosecuting a case against them?
Yeah, so thank you for that. And I think, yeah, I mean, it is kind of, it's pretty outrageous for children to be defending themselves in court, especially in such a complex system that can be difficult sometimes for any attorney to figure out. It's so unlike many of the other court systems that we see around the world, around the US, I'm sorry. There's not rules of procedure, there's not rules of evidence. It's just, it's difficult for anyone to manage. With regards to policy, I'm not as in tune to the policy side of things. I do know that the American Bar Association, as well as a number of other organizations, are pushing for the immigration courts to become independent Article I courts, to at least instill some level of due process for everybody, let alone children in the proceedings. And there is some litigation. I just pulled it up on my computer, but Immigration Council, I put a link. I don't know if everybody can see the answers to the questions, but I put a link in the question that I got to the American Immigration Council. There's a lot going on since about 2014 over this exact issue, the right to appointed counsel in immigration proceedings. And it's still ongoing, but it went up to the Ninth Circuit, and they have not yet found that there is that right to appointed counsel even for children in things. I'm just was looking at it now to get an update. It looks like there's 2 cases before the Ninth Circuit for 2 individual children who were ordered removed by immigration judges while unrepresented by attorneys. And so it looks like, there's still open cases to see if that will go anywhere. But you're, it's a challenge, I think.
Great. Good to hear that is, in fact, there's some traction and potential hope for change there. So we're nearing the hour, and what I'd like to do before we close is actually give each of you an opportunity to share any closing observations or remarks. So Chloe, let's start with you. Any closing observations or remarks for our audience before we adjourn?
I'm really grateful to be on a webinar like this. I think the opportunity to really talk about the intersection of the different work that we're doing in different spheres, even between class action litigators and folks who are on the ground, is really wonderful. So I'm grateful and hope that attendees will look at our Pro Bono Matters for Children Facing Deportation portal and see if there's something that might interest them or share one with a colleague. Thanks so much.
Wonderful. We're grateful to have you with us. Alvaro, you're next. Any concluding thoughts for our audience before we depart?
Well, no, thanks for the invitation. It has been a wonderful opportunity to hear about the perspective of what others are doing. I think from an international perspective, something that we think it might be useful considering the experiences of other countries is to try to use international norms and international standards developed by UN bodies or bodies of the Inter-American system in national litigation. Like in many countries in Latin America or in the European context, the use of the standards and the jurisprudence developed by these bodies has been very useful in order to inform national courts on how to deal with issues relating to to migrants and refugees. And of course that in the long term, but I know that's kind of very challenging in the current context, to keep promoting the ratification of international instruments at the UN level and also at the Inter-American level. That also opens an opportunity for accountability of state officials when they violate human rights norms and obligations, and which is a huge difference. For example, if we see in the way that regional bodies like the Inter-American Commission and the Inter-American Court has to deal with the states of the Americas. Like most of the states might end up being responsible for human rights violation before the Inter-American Court, while in the case of the US, as the US haven't ratified the American Convention, it is impossible to take the US authorities before the Inter-American Court. So yeah, hopefully to keep that issue in the agenda, because it's another avenue for accountability.
Wonderful. Thank you so much for sharing your expertise on international migration law. Lee, you're up next. Any concluding thoughts for our audience before we adjourn?
Nothing for me. I just wanted to thank you guys for continuing to shine a light on this. I think it's critical that we not lose sight of this. I really appreciate you hosting this webinar.
Thank you so much, Lee. We're happy you were able to make it and make it a success. Ryan, you have the last word.
All right. Well,
because you're inspired this event. So.
Well, I'm glad it did, and I'm really glad to be a part of this, and thank all the other panelists too. I think it's been just very interesting to hear all these different perspectives, and I think they're right. And so I guess the thing that I would kind of leave on is that we can do better. We should do better. We have to insist that changes are made. I think one of the lessons, again, from wartime detention operations is that it was the pressure. It was the pressure from civil society. It was the pressure from international organizations. It was the pressure from inside, from the military and from others inside the U.S. government that led to changes that I think were not only needed but helpful in the broader international context as well. So we got to do it. I think we can, and this is a good, helpful part in doing that.
Thank you so much, Ryan. Thank you to all of our panelists for joining us and sharing their time and expertise, particularly during this difficult and challenging time for us as a country and a global community in light of coronavirus. Thank you to all of our members of our audience for taking the time to join us. You will receive in the coming days a copy of the program recording, as well as additional resources that our panelists have been kind enough to share. And we look forward to having you join us next month for our 6th and final webinar in this series, the Muslim Ban Revisited, Trump versus Hawaii. We hope you'll be able to join us. And until then, we wish you well and that you stay in good health. Thank you all.